All right, let's continue with the conversation around the Phala matter, and we focus the attention on what might result of this application by the President at the Constitutional Court. And we speak now to Mpumelelo Zikalala, legal analyst sitting in Durban. Mr. Zikalala, thank you very much for your time. Let's begin with why the Constitutional Court was the preferred avenue by the President. What about the lower courts?
Well, according to the President, he's saying, we are dealing with such an important matter. It's unique. This is the first time in which we are dealing with it. It's in the interest of justice that this matter be dealt with by the ConCourt. And nonetheless, you're also dealing with the conduct of the President. Yes, there may have been avenues in which you can start in your provincial divisions before your matter is then conferred by the ConCourt. But he's then saying, let's keep all those. Let's go directly to the ConCourt and let's not waste any time, because the importance of this matter and the uniqueness of this matter warrants that we bypass all those particular steps. He's basically saying, at the end of the day, you are going to come up with a final ruling in this matter. So instead of me going to all the lower courts, I'm not going to waste time on that one. I'm going to go straight to the ConCourt and let the ConCourt deal with this matter once and for all.
Yeah, that court, Mr. Zikalala, we know now, based on previous experience, and I'm talking about the Jacob Zuma particular case, it takes time to pronounce itself on any matter. And add to that, who's to say that they will agree to hear this matter? Because they could well say, this is not the avenue. Go back, perhaps, to a lower court.
Definitely. You see, there's a reason why this particular avenue was then open, depending on which side you look at it. But one side then says, Mr. President, you are robbing us of the actual legal jurisprudence when it comes to impeachment proceedings and the legal prescripts which we ought to follow by going straight to the ConCourt. Because once the matter has been decided by the Constitutional Court, it can't be appealed anymore. That's the end of it. However, if you start your matter within the Western Cape Provincial Division, for example, you then go to the SA, then the ConCourt. You then have the ability, or we are then given opportunity to then keep on mulling all these particular legal points, all these various jurists and presiding officers that we have, keep on mulling it, and at the end of the day, they bring only the crisp legal arguments to the ConCourt, and only then can that particular matter be pronounced on. So when it comes to enriching the legal jurisprudence, when it comes to all these matters of impeachment, that's exactly the course in which you're supposed to follow. But another point is then saying, we are not going to give you any preferential treatment. You are just another ordinary individual that deserves equal protection from the law, and part of that equal protection means that you have to follow the processes as they are. Or the other decision or other side of the coin can then be, the importance of this matter is so dire, it does not only impact only on the President personally, there are even the markets that you have to consider, the stability of the country that you also have to consider. So let's go straight to the ConCourt and let the Constitutional Court justices hear it and be able to pronounce on the particular matter. So it should depend on how things are. But I do have a strong suspicion maybe those who are going to oppose this particular application, especially on the political side, are going to say no. Go back and start this process afresh and make sure that you go from the provincial divisions before you go to the ConCourt. You can't just shoot straight to the ConCourt even though you have the ability to do so. This matter does not warrant that.
Yeah. Let's then talk to the content of the President's papers in court, Mr. Zikalala. He appears to be attacking not only the powers, but also the evaluation process of this particular panel. Am I reading that correctly, or is it a mistake on my part?
No, you are reading it correctly. However, I would like to add on that one. And why we even said, on the other side of the coin, the President is purely focusing on legal semantics and nothing more. At the end of the day, the terms of references of this particular matter were very clear. You can't pronounce on the innocence or guilt of the President, number one. Number two, all that you have to do is to go and establish whether the facts in which these particular incidents or events stem from, are they accurate or are they true? Can they be verified? Who are the relevant stakeholders? We are not going to give you any subpoenaing powers, so you can't call individuals and tell them or force them to account to you. However, evaluate whatever the evidence which is going to be available to you. Now, the majority of the evidence in which the committee then evaluated is the evidence that comes from the President himself. He is the one that provides probably one of the most detailed and more comprehensive statements than any other individual that is available there. And on that basis, then the committee comes back and says, we do see that there are instances in which we feel that the president ought to answer on these things and clarify this particular issue. By the way, he had an opportunity of doing that in earlier stages. It's just that he did not concentrate or give his full attention to his statements. Maybe because he did not understand that there are consequences of his actions. However, he ought to have known at the time of submitting those statements. So that's all the committee is saying. So the court will then be employed to decide as to when this particular committee is doing its work, what was it supposed to do? Was it supposed to become similar to like prosecutors and then say, this is the evidence that should be evaluated. We have tested the probability of the evidence. We have tested that this evidence cannot be disputed. This is not hearsay evidence. If we go to a court of law, we are going to win. And on that basis, Parliament, please go and institute this particular proceedings. If that's the case, then my question would be, then what would be the committee evaluating at the end of the day if the validity and the accuracy of the evidence has been evaluated by the committee in the first place?
Yeah.
So it is one of those things in which the court will have to delve into and have to check, as we are doing this for the first time as South Africans, have we done it correctly? Or is it a matter of saying, on the next occasion, if you ever have a president you need to impeach, go straight to the impeachment committee and don't start with the Section 89 committee?
Yeah, and I'm glad that you touch on the president's submissions to the panel. And as you say, he appears to be the one that provides the most amount of information. However, that panel, in its evaluation of this information, it did appear to be dismissive, is the word I'd like to use, of the president's submission, to a point where they actually almost say that it shouldn't really be relied upon or it should be viewed with a critical eye. But there's a development. Sky News, which is an international broadcaster, news broadcaster, comes out and reports that they have found Mr. Mustafa, arguably the person who would have started this whole saga. This is the man who comes into the country carrying thousands, $580,000, and he makes this purchase in cash. Well, he has been found. He actually is a living human being. And now that he has been found, do you think that that strengthens the case of the president? Does that strengthen whatever his submissions were to that panel, as opposed to how I've framed this particular question from the start to say the panel appeared to be dismissive or at least suspicious of the president's submission?
Not necessarily. Let's look at what the panel is trying to identify. Here we are solely dealing with Section 96 of the Constitution that looks at three things. Did the President commit a serious violation of the Constitution or the law? Has the President put himself in a compromising position in which is going to be in conflict with his own interest and that of the country? And lastly, did he use his particular position or his position as the President of the country to improperly benefit himself or anyone who's close to him? There are three points in which we need to look at. So, in your assessment of all these points that we're dealing with, you have to go back and check, are there any of those transgressions that have taken place? The first one and the most glaring one is, should a president participate in the business activity of being a farm owner or a buffalo trader? When that particular amount then comes into the country, shouldn't he follow, if he is the sole director of that particular entity, all the laws that would apply to you and me when it comes to how that particular case should be handled? Shouldn't he have followed a process of saying that because I'm receiving this amount of money, there are FICA requirements that I need to comply with as a person who's going to receive these amounts? I need their ID or passport, their proof of residence. I need to make sure that there's a proper invoice and statement that I'm going to hand over to them, because I'm also going to be accountable to SARS at the end of the day. These are all the points in which point to the possible contraventions of the Constitution or the law. And these are all the points that point to a situation where the money has been stolen. You then find a president who, in his own admission, is going to say, I reported the matter to the person who was next to me because he guards me on a daily basis. And I did not go to a police station as Crowley would go whenever there's a burglary that has happened at his house. But mostly, there's no case number that has been submitted in which you and I would then expect to find when you've reported a particular crime. Not to add the fact that this happened more than 24 months ago. Then the question is, what have the police have been doing so far? Wouldn't you want to give a report to where the police are in your submissions to a very important committee such as the Section 89 committee? So at the end of the day, the elements of the people that keep on cropping up add on to the aspersions that can be drawn or allegations that are there of saying that, Mr. President, you may have contravened Section 96 of the Constitution. In order for us to determine whether the contravention took place or not, we need to hold an impeachment process or some type of process to hold you accountable so that you can be able to answer in a much more formal and proper manner and in an institution or a committee that has subpoenaing powers. They should be able to call the purchaser and say, you must come to South Africa and account. Why didn't you go through SARS? Where did you get that large amount of money? Where was it stored? When you walked into the gates, how were you carrying it? Because we are not dealing with 5 rand or 400 rands. We are dealing with larger amount of money. So at the end of the day, these are all the questions that the committee could not answer. And they are right in what they've stated. They are saying, we cannot say that you are guilty or not guilty due to the limited powers that we have, but we do feel that another committee with more powers would come to a much more conclusive conclusion.
All right. So let's conclude the conversation on a slightly complicated note, and please hear me out. I'll try and be as slow as is possible. So if we look ahead to next week Tuesday, that's when this report is going to be debated in Parliament. Should there be a push there for an impeachment process, right? The analyst I spoke to yesterday, Professor Mdletyana, says an impeachment process is something of a quasi-judicial process, but in the main, it is political, all right? So keep that thought in mind. Now the president has run to the Constitutional Court to say, no, this was wrong, and I'm coming here on an urgent basis. Here comes now these 3 pillars of the state: the judiciary, Parliament, the legislature, and the executive. Are we going to see a situation here where what ought to have been a political process is now being thrown in the courts? Once again, the courts are being looked to arbitrate on this element. Who's to say that these arms are not going to, are not going to encroach into each other's spaces?
You see, the chances of that happening are much alive. But this must be distinguished. If you look at Section 89, it says nothing about a pre-identification or pre-inquiry committee that has to sit aside before Parliament sits down and decides whether the president has to be impeached or not. So Parliament can come back next week, Tuesday, and say, we are going to disregard this report. We're not going to even read it or even consider it. We are purely discussing this particular matter based on the rules of Parliament and based on what we are going to vote for as members of Parliament. If we decide that impeachment proceedings must be held, not having taken account the report that comes from the committee, then that's exactly what we are going to do, because that's what the Constitution empowers us to do. Let's go and set up those processes and let's continue with them. If the committee or Parliament then comes back and says, our saying yes or saying no is going to solely depend on what the recommendations of the committee are, then they could be stalled in arriving at that particular decision up until this court matter has been done and dusted, or the Constitutional Court is pronounced on the matter to determine whether it is wrong or right. What the courts can and cannot do is this. The courts cannot dictate to Parliament how they should run their affairs unless there's been clear contraventions in terms of the Constitution. But in this case, the impeachment process are completely parliamentary, if I may put it like that. It has nothing to do with the courts whatsoever. It's the Parliament that determines how this particular matter should be. The judiciary is only there to check whether things were done according to the rules of Parliament and whether everyone was given the opportunity to respond to whatever allegations that were there in terms of the rules of natural justice. Other than that, Parliament can still continue. It will solely depend on how the invitation to the meeting is phrased, the invitation to or the content of the discussion of what is being discussed or debated in Parliament is going to be phrased. If it's going to solely depend on this particular committee report, in terms of saying, remove this report and your agenda has collapsed. On that basis, then I would say you can't continue those proceedings up until the ConCourt has decided the matter. However, if they are going to come and say, we want to proceed on these particular matters based on the powers that we have as parliamentarians, it has nothing to do with the report. We simply want to deal and make sure that we are able to hold the President and all the other institutions which are linked to this matter accountable. Then I would say they can continue.
Mpumelelo Zikalala, thank you very much for making that all digestible for us. It's legal processes can be steeped in jargon, but thank you very much for the effort to explain this to us in layman's terms. And